Ladies and gentlemen, thank you for clicking on the video. My name is Dustin. Today I'll be discussing the recent ruling in a case that went before Trump-appointed Judge Dominic Lanza in the Ninth Circuit Court of Appeals regarding a former deputy warden who retaliated against an inmate's protected free speech by having him transferred to a different yard. Then I'll discuss Arizona Governor Katie Hobbs' new prison oversight committee. Let's break it down. The First Amendment of the United States Constitution guarantees 5 fundamental freedoms. Quick recap: those freedoms are freedom of speech, freedom of the press, freedom of assembly, freedom of religion, and freedom to petition the government for a redress of grievances. This is the right to freely complain to your government about your government without fear of reprisal or retaliation. Deputy Warden Vivian Baltiera was alleged to have violated that 5th guaranteed freedom under the First Amendment by having an inmate transferred to another yard as punishment for filing a grievance back in 2017. A grievance is the process an inmate uses to complain about an issue. Sometimes it's for neglected medical services, sometimes it's for lost or stolen property, for example, something taken by a prison guard during a search even though you were allowed to have it. It is how an inmate can complain about misconduct of an officer. Sometimes it's how snitches snitch. It basically gives any inmate the ability to put anything in writing and give it directly to whichever corrections officer they choose. So back to the warden. Vivian Baltiera is a 2008 graduate of the Certified Public Manager program from Arizona State University's School of Public Affairs in the Watts College of Public Service and Community Solutions. This school states that it helps students enhance their management and leadership competencies. I'll ask you to decide whether or not that holds true. Let's introduce the main character of tonight's story. This is Stephen Karban. Stephen is serving a 138-year sentence in Arizona for inappropriate conduct with a minor, a crime which he asserts never happened. Mr. Karban's story is important because if we don't make sure our American values and our constitutional rights hold fast and true for those who commit even the most egregious crimes, then it's only a matter of time before they come slap a label on you that lets them take your rights away too. This story begins in the prison visitation room in 2017. Square tables with one chair on each side, a small patio outside, vending machines in the corner. Half of the people in the room are wearing nuclear neon orange, and almost everyone is playing board games or cards. Mr. Karban's loved one was visiting him at the prison. They were sitting at a table when a corrections officer told them that their legs were touching and they needed to sit farther apart. Mr. Karban was later issued a disciplinary ticket for the incident. He appealed the ticket and won a dismissal. The problem is that the discipline begins almost immediately, but the appeal can take weeks. The penalties for disciplinary infractions vary, but generally they include restrictions typically referred to as loss of privileges or LOPs. Your property is taken from you and held in storage. These items include your radio, CD player, television, anything that would be considered a luxury item in prison. It doesn't matter that you paid for it, you own it, and you can take it with you upon your release. The prison will deprive you of your personal property for perceived infractions of institutional rules, policies, not laws, in the name of prison safety. On its face, this appears to conflict with our Fourth Amendment right to be secure in our person, papers, and property without due process. On the other hand, due process is already played out to some extent, or they wouldn't be incarcerated. Other privileges you might lose include phone calls, visitation, and your ability to order commissary. This specific restriction gives rise to opportunistic exploitation, as people on the yard will lend you items now with a promise to pay back more later. One of the last things any prisoner wants is unpaid debt to another inmate, as debt collection can often be a violent process. Regardless, by the time Mr. Karban won his appeal and dismissal of the disciplinary ticket, his 30 days of LOP had already been served. His only recourse was to write a grievance about the officer who wrote the false disciplinary ticket and request that she be investigated for her misconduct, so that's what he did. Now, this is where the story takes a twist. According to court filings, which say not for publication, so don't tell anyone I told you, Vivian Baltiera, former deputy warden at a prison yard called Cook Unit in Florence, Arizona, emailed the warden of a different prison unit to request a 1-for-1 transfer for Mr. Karban less than 2 weeks after he won his appeal of the disciplinary ticket. Her email stated Mr. Karban was, quote, not a yard problem and he likes paperwork. Liking paperwork could colloquially be understood to mean that the inmate files lots of grievances. In other words, they like to complain, often and in writing. Correctional staff and law enforcement in general seem to have a particular disdain for paperwork, as evidenced by the myriad inconsistencies between official reports and body-worn or security camera footage. On March 26, 2021, Mr. Karban filed a lawsuit against the warden for First Amendment retaliation and lost his trial by summary judgment, so he appealed. Upon review of the case, the Ninth Circuit Court of Appeals, which oversees Arizona, opined that, quote, summary judgment was improper on Karban's retaliation claim against defendant Baltierra. The record reflects that approximately 2 weeks after Karban filed a grievance, Baltierra requested Karban be transferred. In the transfer request, Baltierra stated Karban was, quote, not a yard problem and likes paperwork, end quote, end quote. All right, so let's take a beat and unpack some of this. What is summary judgment? Summary judgment is a judgment entered by the court for one party and against the other party without a full trial. During a trial, after both parties rest their case and the jury begins deliberations, either party, the plaintiff or the defendant, can ask for summary judgment. This is a request for the judge to rule in their favor on the case before the jury returns a verdict based on the facts presented and the law surrounding the matter. And if the judge so chooses, they may rule on the case and disregard the jury's verdict entirely. This is how Stephen Karban lost his case initially. During another trial, we learned that the Department of Corrections was somehow unable to fully access their database of security camera footage and therefore could not comply with the court's order to turn over all available video evidence from the incident in the visitation room as discovery. Mr. Karban has a legal right to obtain this as evidence for his lawsuit. These are essentially public records subject to Freedom of Information Act laws. Had there been an actual emergency, the prison would have been unable to supply the relevant video evidence, or that's what they would have us believe. It appears that the prison withheld exculpatory evidence, that is, evidence that would have proved Stephen Karban did not violate policy in how he was sitting next to his visitor. The missing tapes are like our own tiny little Watergate. The only video the prison produced was one that didn't directly incriminate nor implicate the warden, and it didn't show the angle where you'd clearly be able to tell whether their legs were really touching. There was a camera there, the state just didn't produce the evidence. This could be considered spoliation of evidence. Spoliation arises when one side of a lawsuit uncovers that the other party has deliberately, negligently, or accidentally destroyed evidence relevant to the case. Spoliated evidence can include physical objects like a murder weapon, photographs, or in this case, videos. When spoliation occurs, a jury may be instructed to assume that the destroyed evidence would have been favorable to the other party. In this case, the warden amended her deposition testimony, also known as interrogatories. Initially, she asserted that she did not initiate Mr. Karban's transfer and did not know the reason for the transfer. Later, one of Baltierra's emails surfaced that showed she, in fact, did initiate the transfer. It also stated plainly that she wished to transfer him because he likes paperwork. She also acknowledged that he was not a yard problem. This essentially is her confessing that there was no legitimate penological purpose for moving Mr. Karban. The DW then crossed out the sentence from her interrogatory in which she asserted that she did not initiate the transfer, nor did she know why it was initiated. During the trial, she stated that so much time had passed and there were so many inmates that she just didn't remember. Again, in her initial sworn testimony, she didn't say that she didn't remember. She asserted that she was not involved in the transfer in any way. The difference between I don't remember and I definitely wasn't involved is non-trivial. It was as if she was saying, I know who did it and it wasn't me, even though it really was. For the rest of us, this would be called perjury. However, if you work from within the system, you can just change or amend your testimony as you see fit after the fact as new evidence against you emerges without fear of any consequences. In order for her to be held accountable for lying under oath, her attorney, which is the state of Arizona, would have to prosecute her. In order to hold her accountable, they would have to prosecute their own client. It's not going to happen. Mr. Karban had to wear his orange prison clothes during the trial. Luckily, he was unshackled and uncuffed. This isn't always the case. Judge Lanza, or as I call him in my head, Judge Superman, as he has a very Clark Kent look and vibe about him, denied Mr. Karban's request to have an attorney appointed to him. Since Mr. Karban is in the custody of the Department of Corrections, he is essentially a ward of the state. If he doesn't deserve to have an attorney appointed to him, then who does? Don't our Miranda rights explicitly state if you cannot afford an attorney, one will be appointed to you? Nevertheless, Steve presented his case like a boss. He nailed every legal argument. He cross-examined himself on the stand. He asked himself questions, waited to see if the state was going to object, then answered his own question to the jury. He absolutely eviscerated D.W. Baltiera on the witness stand. He masterfully walked her through all 5 times that she changed her story and her testimony. Now, an interesting note in this case is the burden of proof. Most of us are familiar with the standard beyond a reasonable doubt. That's necessary to convict someone of a crime, but this case was different. This was a federal civil rights case, so Mr. Karban only had to prove his case by a preponderance of the evidence. That simply means more likely than not, 50.1%. It's a significantly lower threshold and therefore a much easier burden to meet. Another element of the case required that Mr. Karban show that the improper transfer was harmful. After the transfer, Mr. Karban lost his job within the prison and was forced to work a job that was physically demanding, despite his age and physical limitations. Mr. Karban was injured while working and has been unable to work since. Mr. Karban was eventually moved to a building with a severe bedbug infestation. He has yet to file another grievance for fear of further retaliation. Some of you may remember that LaShawn Johnson recently died in a Fulton County jail cell in a psych ward after being eaten alive by bedbugs and other insects and parasites. The picture of his body is too graphic to show here, but here's a picture of his cell. I've been in cells like this in Arizona and worse. This is no trivial matter. These are basic standards of living, and they are not being met by our state institutions. This is a serious failure of government. This is gross negligence on a massive scale. According to prisonpolicy.org, Arizona's present incarcerated population is 52,000 people. At a rate of 868 per 100,000, Arizona has a higher incarceration rate than any democracy on earth. Nevertheless, a jury of 7 unanimously agreed that Mr. Karban proved by a preponderance of the evidence that Vivian Baltiera retaliated against him for putting pen to paper and that it caused him harm. Mr. Karban was awarded damages in the amount of $2,000. And because this is a 42 U.S. Code 1983 civil action for deprivation of rights, this settlement will not be paid by the taxpayers. There is no qualified immunity here. This comes directly out of the pocket of ex-Deputy Warden Vivian Baltiera. This is true accountability. Let's hope this sends a strong message to other would-be oath breakers. This is, however, sadly just one example of why we need comprehensive prison oversight. We've known about these issues for years, and finally, the one-man army that is Stephen Karban was willing to face the full force of the state, and he won. He stood on his rights, and he won. And his victory is not one for himself alone. This verdict will force change. In January of this year, 2023, Arizona Governor Katie Hobbs said, "We cannot deny there is an urgent need to provide transparency and accountability in Arizona's corrections system." Then Governor Hobbs put her pen to paper and signed Executive Order 6, which created a civilian oversight committee with 10 members. 2 state senators, 1 from each party, 2 members of the Arizona State House, 1 from each party, someone who represents an inmate advocacy organization such as the ACLU, someone with a background in inmate training or rehabilitation programs, 2 members who were previously incarcerated, 1 male, 1 female, a physician, a mental or behavioral health professional, 1 family member of an Arizona prisoner, and lastly, someone with a background in corrections, likely someone who's worked within the prisons themselves. It's my understanding that the following people will be serving on this new committee. Khalil Rushdan is set to chair the committee. He was previously employed by the ACLU and is directly impacted by the justice system. Kara Jansen is presently employed by the ACLU and is directly impacted by the justice system. Annalise Ortiz is the sitting House representative for LD24. She serves on the House Judiciary Committee. She was also previously employed by the ACLU. Walter Blackman is the former Arizona House Rep for LD6. According to the Arizona Legislature website, Blackman was endorsed by the Phoenix Chamber of Commerce, the Arizona Firefighters Association, the Arizona Fraternal Order of Police, the Phoenix Police Association, the National Rifle Association, the Arizona Right to Life Association, the Payson Tea Party, the Navajo Country Republican Club, and the National American African Republican Committee of Phoenix. I think this list is incredibly well thought out. It brings stakeholders from every arena with particularized experience, perspectives, and interests. It's also important to be looking for prison corruption and exploitation in all of these areas. They also are all vital components of rehabilitation and successful reentry after prison. 96% of everyone we incarcerate is eventually coming back home to our community. That's why it matters how we treat them on the inside. How could anyone come out and successfully participate in a society that denied their basic humanity and their basic rights? I look forward to seeing who else is serving on the committee, because I believe that protecting our nation from all enemies, foreign and domestic, is the duty of every American, whether you took an oath or not. In this case, the deputy warden broke her sacred oath and violated Stephen Karban's natural right to be free from retaliation for exercising his constitutional rights of free speech and to petition a redress of grievances with government employees. In my opinion, this makes her a domestic enemy that our incarcerated loved ones need protection from. How many more Baltieras are out there that have never been forced to face their day in court? My personal experience of incarceration has taught me that corrections staff believe retaliation is a necessary component of institutional security. They think if they complain and we give them what they want, then they'll just keep complaining and asking for more things. They don't care if it's a rights violation. The ingrained culture deems it a necessary component of institutional security. As Dr. Ritchie says, culture eats policy for breakfast, lunch, and dinner daily. So now, hopefully, maybe, next time they'll think twice, or maybe they'll just do a better job of covering their tracks. If you would like more information about Steve, he has written a book called Arizona Department of Corrections, An Insider's Look at Chaos and Corruption. His ebook is available at stephenkarban.com for only $3.99, and it would go a long way towards helping him survive on the inside. Please hit that like button, share, subscribe, turn on that notification bell, and let me know what you think down in the comments. I will see you on the next one. Thank you so much for watching.